This rather unusual civil procedure case arose from a car accident. An unregistered, uninsured car driven by Dejan Radulovic overturned, and Zvonko Bradvica died as a result of his injuries. His wife, who was also his executor, sued on her own behalf and on behalf of his son, claiming damages as Bradvica's defendants. Before she got anywhere near suing, however, the driver, Radulovic, fled the country and returned to his home village in Serbia within the very temporary nation of Yugoslavia. The plaintiff sought to make the usual arrangements for service out of jurisdiction. It's not entirely clear whether the problem lay with Australian officials or Yugoslav officials, but either way, the documents could not be served. She then approached the court for an order for substituted service and received an order that she must serve the documents by mailing them to Radulovic's address in Yugoslavia, which was known to her. She was also required to serve the incorporated nominal defendant, a body which exists to provide compensation to people if the vehicle which damages them is uninsured. The nominal defendant sought to have the order for substituted service set aside. Justice Gillard said, "It would appear somewhat unjust to the plaintiff that if she in fact is entitled to damages, her claim cannot be prosecuted merely because of the apparent failure of government officials, here and abroad, to effect service. The action of the master in granting an order for substituted service in the form that he did was completely understandable." At the same time, the situation was unusual because there was no way to know if Radulovic ever actually received the documents. Justice Gillard said if the defendant should in future remain silent, it probably would never be known whether or not he received the papers through the post. Where there is no real incentive for him to inform the plaintiff that he received the papers, the defendant might very well remain silent. From a practical perspective, however, the ultimate defendant in the matter was always going to be the nominal defendant, and they were well aware of the claim. This practicality seems to have provided much of the basis of this decision. From this case, we learn that in an appropriate case, mailing documents can constitute good service, even though it cannot be verified that the documents are received.